Hey, good afternoon, everyone. There's quite a few people have joined, so we will begin now. I hope this is the right time. So this is one of the seminars in a series run by Donnchadh called the Equality Act 2010. This is a seminar about the Equality Act in judicial review, and it's presented by Donnchadh and I, we are both barristers at Donnchadh Chambers, and we specialise in judicial review and discrimination, among other things. And we're going to split the seminar into two topics. One topic is an overview of the use of the Equality Act in judicial review, picking up a few sort of key issues for claimant practitioners, things that you might find useful as a claimant practitioner in bringing a judicial review claim which relies on the Equality Act. And then Donnchadh is going to look at a case law update of a few key recent cases. So I hope you've got some seminar notes. I've produced some word notes, and I'm going to follow through the same structure as the word notes. And they're split up into various sections. The first section is about how the Equality Act applies to public functions. You probably know the Equality Act is, it starts off by defining the protected characteristics, race, sex, and so on. It then looks at the types of discrimination, so direct discrimination, indirect, failure to make reasonable adjustments, and so on. And then the rest of the Act, or at least the majority of the Act, is the application of those different concepts in different contexts. And those contexts include things like work, education, associations, and then part 3, services and public functions. And as an administrative lawyer, those are the parts you need to look at. And it says that section 29 for you as a public lawyer is the most important one. That's the application of the discrimination provisions to this context. And it starts off and talks about service provider. And you may think, well, as a public lawyer, why do I care about service providers? But unfortunately, you need to, because service provider is given rather broad meaning in this context, and it can extend to quite a few public functions. So section 29 says that a service provider must not discriminate against the person by not providing the service or in the way that the service is provided. And then it says that, subparagraph 6, a person must not, in the exercise of a public function that's not the provision of the service, do anything that constitutes discrimination. Discrimination means all the different types of discrimination, including a failure to make reasonable adjustments. So various examples of service versus public function have been given, and the overlap between them is pretty complicated. So examples of service have included medical treatment on the NHS, allocation of work to prisoners, certain aspects of policing, whereas the examples given of public function are quite similar. So other aspects of policing, receiving someone into prison, have been given as examples of public function. But don't worry too much about the distinction, because if you're in any difficulty in deciding whether the particular claim that you're making falls into one or another category of it, just pleading it as an alternative. So have this is a service, alternatively it's a public function. Now, as a public lawyer, one of the real difficulties are the exceptions that are applicable to this context, because there are quite a few exceptions to the protections from discrimination that may be relevant. And I've given a few examples in the notes, but I'm afraid it's not all of them, and it's really important to make sure you're on top of all of them and understand some of the complexity. So a few examples: parliamentary or judicial functions and the army. So the prohibition on discrimination in section 29 doesn't apply to the exercise of a function of Parliament, preparing, making, or considering primary or subordinate legislation, including statutory instruments. Now, as a public lawyer, that's a really important one for you, because it means essentially that you can't challenge primary or secondary legislation using the Equality Act. And that's why a lot of challenges to primary and secondary legislation raising discrimination issues normally rely on Article 14 of the ECHR, which is applicable to that. Further exceptions, judicial functions. And then so far as relating to age, disability, gender reassignment, sex discrimination, anything done for the purpose of ensuring the combat effectiveness of the armed forces. Another exception, national security, so that security intelligence services aren't subject to the prohibition, and anything done for the purpose of safeguarding national security that's proportionate to that purpose, again, is exempt. There's slightly complicated provisions if a public authority is required to do something by enactment or by a relevant requirement or condition imposed by virtue of an enactment, then again, the prohibitions don't apply. And there's a few caveats to that that's in paragraph 10 of my notes. Immigration, it's quite complicated. Certain quite specific exceptions relating to immigration. For example, in relation to nationality or ethnic origin discrimination, where a minister of the Crown acting personally or a person acting in accordance with a specified authorization given by a minister of the Crown, those functions are exempt from the discrimination provisions so far as they concern nationality or ethnic origin. So it's quite specific. Similar one applies to age. There's something in relation to disability discrimination and religious or belief. There's a certain specific exception as well. You have to be a bit careful about those. On the other hand, in the immigration context, Section 29(9) it expands the protection from discrimination in a way that might not be expected to start with, in that it gives it a certain element of extraterritoriality. And that is that when Section 29 is applied, when one of those exceptions doesn't apply, but Section 29 is applied so far as race or religion or belief are concerned, to the granting of entry clearance in immigration, it doesn't matter whether the act is done within or outside the UK. So entry clearance decisions, discrimination based on race and religion, have an extraterritorial effect. Other than that, however, a Supreme Court case called Maroof, a very recent one, confirms that the Act doesn't generally have extraterritorial effect. Maroof concerns public sector equality duty, and it was a claim brought by a Palestinian refugee who was complaining who wanted to benefit from the ex gratia scheme that was available to Syrian refugees. And he made an argument that the public sector equality duty hadn't been carried out by considering the discriminatory nature of that scheme. And the Supreme Court said, well, he was outside the UK. There was essentially no connection to the UK between him and these schemes at the time that the schemes were formulated. And so there was no public sector equality duty in respect to a person who had no connection to the UK. So extraterritoriality generally, it doesn't apply. And carrying on to paragraph 14, charities, there are some exceptions, and then 15, sex discrimination. There are various fairly complicated exceptions related to sex discrimination. Donnchadh is going to deal with the recent For Women Scotland case, which these are irrelevant to, but just to give you a bit of an overview. A person does not contravene Section 29, so in other words, they don't act unlawfully, by providing separate but equal services for persons of each sex. If providing a joint service for both sexes together would be less effective, and providing separate services is a proportionate means of achieving this aim. There's a similar exception relating to the provision of separate services differently. So the one I just covered was separate but equal services. Separate services differently have the same criteria, but there's an additional one, which is that it's not reasonably practicable to provide that service otherwise than as a separate service provided differently. So you're basically looking at sorry, an entrance to the room, something like that. And so you're basically looking at first Effectiveness, so that they have to be less effective if they're provided jointly, proportionate means of providing a legitimate aim, and not reasonably practical. So an example of that exception being applied is the case of Cole, and that was a case in, sorry, I'm just going to pause while something technical happens. I think we're going to continue.
I can't hear you guys. I'll send James over again.
Great, can you hear us now? Is it just that we're very quiet?
Yes, all good now. All good now.
Right, okay.
Thanks. Okay, sorry about that, everyone. We'll carry on. And please do, if you have any questions that you go along, please do put them in the chat. Hopefully the Word document will be circulated again shortly. So, so I'm on the example of the exceptions to sex discrimination about providing separate services to the different sexes. So one service for men, one service for women. And the example of that is the case of Cole, which was a 2017 Supreme Court case about probation hospitals. And different probation hospitals were singles gender, so either men or women. And fewer of them were provided for women, which meant that women had greater risk of being further from home. And that was a disadvantage for all sorts of reasons to various women. And the Supreme Court decided that that was direct sex discrimination. And it was capable of being lawful under this provision. So it was capable of being a separate service and a proportionate means of achieving legitimate aim. But the Supreme Court decided it wasn't justified under that exception. The Secretary of State was unable to show that it was a proportionate means of achieving a legitimate aim. And that was because it hadn't complied with the public sector equality. And that's quite a useful finding if you're bringing a claim and there's no, well, there isn't sufficient evidence to show that the defendant has complied with the public sector equality duty. It's important to bring that alongside direct discrimination or other discrimination claims, because if it turns out that the PSED hasn't been complied with, that can be helpful when you're establishing your other types of discrimination claims, your direct or indirect discrimination claims. The Supreme Court also held that a saving cost can't justify direct discrimination. If you want to save costs, you have to do it in a non-discriminatory way. There are some other exceptions relating to sex discrimination, which is set out in my notes. One of them is that if a person of one sex might reasonably object to the presence of a person of the opposite sex, and again, it's a proportionate means of achieving a legitimate aim, then there's an exception there. And an example is given in the explanatory notes to the Equality Act. A massage service provided to women only by a female muscle therapist with her own business operating in her clients' homes because she would feel uncomfortable massaging men in that environment. Just an aside at this point, there are some pretty helpful examples, both in the explanatory notes to the Equality Act, which are really full and very helpful, but also in the various codes of practice that have been produced by the Equality and Human Rights Commission, and all of those can be found online. Okay, so those are the exceptions. I'd like to move on now to the public sector equality duty. I'm sure you all know about that already. It's section 149 of the Equality Act, and it states that a public authority must, in the exercise of its functions, have due regard to the need to eliminate discrimination, achieve equality of opportunity, and so on. And a few key points about that duty. Firstly, it's very important. It's recognised throughout the case law as being very important. It's proactive. So it's not just about responding to equality impacts that are already known. It's about discovering them as well, even if they're not immediately apparent. It applies whenever anyone exercises a public function. And that's the whole swathe of public functions, whether the formulation of policies, big decisions, or even decisions in individual cases. It's triggered when there's grounds to suspect that the exercise of a public function might have an equalities impact. So it's a low threshold for triggering a duty. It may require a public authority to monitor the equalities impacts, so to gather data. Little paragraph F in my notes sets out the test that the court is applying as to whether the public authority has met the PSED. And perhaps the most important aspect of it is not a Wednesbury test. It's not a matter of whether a reasonable authority did what it did. The court has to be satisfied that there's been rigorous consideration of the duty, that the decision maker assessed the risk and extent of any adverse impact, and the ways in which the risk could be eliminated. If the defendant doesn't produce evidence to show that the duty has been complied with, then that may lead to a breach, a finding of a breach. And the PSED can also have a duty of inquiry. So that's to obtain evidence of whether there's an impact, an adverse equalities impact. But that part of the duty is a little bit more difficult because there probably is a Wednesbury test for that aspect of the duty. So you have to show no reasonable authority could have carried out the inquiries that the defendant did. Okay, the next topic is enforcement and remedies. Enforcement and remedies, the part of the Equality Act that you need to know about as a public lawyer is Part 9, and you need to know sections 113 to 115. The key points are that the starting point for claim for breach of the Equalities Act in this context, so concerning a service or a public authority, public function, sorry, is the county court. So that's the primary route of relief. There are certain specific decisions which will have to be brought elsewhere. For example, there are certain immigration decisions that have to be brought outside the county court in the immigration in tribunal or in SIAC. However, judicial review is expressly preserved in the Equalities Act. It's in section 113. And you can essentially bring a judicial review claim rather than a claim in the county court if there's a good reason for doing so. I'll come back in a moment to look at a couple of examples when there may be. If you're taking the first route, so claim in the county court, you have to give notice of the commencement of the proceedings to the Equality and Human Rights Commission. And normally, an assessor will be appointed in the county court unless the judge is satisfied that there's good reason for not doing so. The county court can apply any remedy that's available in the High Court, including on judicial review. So it can apply a mandatory order, a quashing order, declaration, and so on. And of course, it can provide damages, including damages for injuries to feelings. The ordinary time limit for a county court claim is 6 months, but that doesn't alter the judicial review time limit. So judicial review, as I say, the right to make a judicial review claim is expressly preserved. As a public lawyer, you'll be aware that if there's an alternative remedy to judicial review, then you will be expected to take that, but only if it's equally effective. And so if you can show that a claim in the county court is not going to be equally effective to a claim for judicial review, then you can make a claim in the admin court. And there's all sorts of reasons why it won't be equally effective. One of them, this is paragraph 31 of my notes, is that there are some claims which can only be brought by judicial review, which include, for example, a claim for a breach of a freestanding claim for a breach of the public sector equality duty, freestanding claims that the public authority breached public law. And if you're bringing a claim which alleges a contravention of Part 3 of the Equality Act, together with one of those claims that can only be brought in the administrative court, then you often have a good argument that it's better that one claim resolves it rather than two. In other words, you can bring the claim in the administrative court rather than having to bring two separate claims, one in the admin court and one in the county court. So that can be one basis of how you can get into the doors of the admin court if you've got a separate issue which can't be brought in the county court. Some claims can be brought by both means, judicial review or in the county court. But even if your claim can be brought in both forums, there may be some other good reason for bringing it in the admin court. For example, if the case raises a pure public law point or a pure point of law, point of statutory construction, that can be a good reason for bringing it in the admin court. And I think an example of that is the Full Women Scotland's claim that Donnchadh is going to discuss. The case law has also suggested that if judicial review will be faster, that may be relevant to whether there's a good enough reason for you to bring it in the admin court. On the other hand, there are certain circumstances which will point towards the county court or may make it inappropriate for you to bring it in the admin court. And one of those is if there's going to be a need for oral evidence, the disputing evidence, which the admin court is generally reluctant to hear oral evidence, although in certain cases it can do. The ordinary time limit, I mentioned the 6-month time limit in the county court. JL time limit remains the same, even if you're bringing an Equality Act claim. So it's promptly and in any event within 3 months. So moving on to the last couple of sections of my seminar, I'm just going to check the Q&A to see if there are any further questions. Okay, there's a question about which evidence is most useful for practitioners to obtain to determine non-compliance with PSED, impact assessments, consultations, etc. In some ways, the starting point is what evidence has the defendant put forward to show compliance. If the defendant hasn't produced evidence to show that they complied with the PSED, then often that will mean there will be a breach. Unless it's obvious or there's some other reason to determine that they have complied with it, then that will often lead, of course, to concern that there is a breach. But you as a claimant lawyer are really in the defendant's hands. It's their job to comply with the PSED. You can, in your letter to court claim, you can say, we haven't seen any evidence to show you complied with it, or you haven't shown that you've adequately complied with it. If you have complied with it, please give us the evidence, otherwise we will ask the court to conclude you haven't. So remedies, the remedies open to the admin court in the Equality Act context, as well as the same as in any other context, so question order, mandatory order, and so on. And I've given in paragraph 38 a few examples of declarations that have been granted in this context. So the first of those is the case of Cole, which I discussed a little a moment ago. And the declaration was along the following lines: the provision of approved premises in England and Wales by the Secretary of State constitutes direct discrimination, which is unlawful unless justified. No such justification has yet been shown by the Secretary of State. So it's quite an interesting declaration. It's quite a flexible remedy, the declaration. It not only identifies direct discrimination, but it also says, it opens the door to the Secretary of State, well, you can justify it, but you haven't yet shown it. Birmingham City Council was a case involving the provision of grammar schools, and it was quite similar to Cole. Fewer grammar school places were available for girls as compared to boys, and that was found to be direct discrimination. and a declaration along similar lines was made. So the arrangements currently made by the council, the provision of selective secondary education, were unlawful direct discrimination. And the third example is a case of Ward. This concerns a local authority's housing allocation policy, which gave priority to people with 10 years residence. And the declaration was the impugned provisions of the policy constitute indirect discrimination against Irish travellers and non-UK nationals, which is unlawful unless justified. Hillingdon has not yet shown such justification. So a similar thing to Cole. And one reason for raising those is that even from the very start of the claim, you need to be thinking about exactly what declaration you want, what remedies you want, and beginning to formulate it and base the claim about that. So that's just a very brief run through some of the key provisions that may be useful for public lawyers. Obviously, if you're acting in this area, there's a whole lot more that you need that I've missed out. So, for example, you need to be aware of the protected characteristics, all the different types of discrimination, and the normal rules of judicial review. But all I've got time for really is to point to a few resources which are at the end of my notes, which are various online resources and books. And you can also try this excellent book by Lag, the Discrimination and Public Law book. I think I've got 1 minute left before I hand over to Donnchadh. So the title of this talk and the series is Past, Present, Future of the Equality Act. I hope I've covered past and present. In terms of the future, the Labour government has made a couple of commitments which are relevant to public lawyers in this area. The first is that it's committed to bringing in Section 14 of the Equalities Act, which is a provision making combined discrimination unlawful. At the moment, under the Equality Act, combined discrimination is not unlawful. So you have to show you were discriminated against on the basis of one ground alone. So sex discrimination, or race discrimination, and so on. But the Labour Party are going to bring in combined discrimination. So you can say, I was discriminated against on the basis that I'm a young woman, or something along those lines. So two things bringing together. There's also a consultation on the PSED, and the government is consulting on whether it's necessary to amend the Equalities Act to strengthen the PSED's application to private or voluntary sector organisations. And then the third point that may be relevant, the Labour government has said it will commence the socio-economic duty in England. That's already in place in Wales and Scotland. But what it essentially requires is there to be due regard to the reduction of socio-economic disadvantage, and it's hoped that that will be brought in relatively soon. So that's my talk. I'll hand over to Don.
Thanks very much. Really helpful, and I have presented some slides. I will circulate them. I'll have our very helpful marketing team helpful team members, and we'll send this round after the talk, as I need to just add some references to make it more useful for after the talk, but I'll as I go along. So building on from what Adam has said, I'm going to look at some recent case law updates. Mentioned where the Equality Act is applied in the context of judicial reviews. As the theme is past, present, and future, what I'll try to do as I go along is look at where the Equality Act has been, where it's at, and where we're likely to have issues in the future, or possible consequences from these cases, and what they really say about the Equality Act. Next slide. So I'm going to provide a brief overview of my top five, and then I'll provide a case law update, as I said, about future issues where relevant, and looking at the circumstances of those cases. Next slide, please. So these are the cases I'm going to look at. I think taken in that order because it'll flow from each other. The first two relate to points relating to the kind of what is often known as the clash of rights between women and transgender people, or as under the Equality Act, as Alan said, gender recognition, and then under the further other cases, I'm going to look at the Equality Act in the context of immigration. So starting off with the case that has scarcely been out of the news recently, we're going to look at 4 women in Scotland. Next slide, please. So I was discussing it with Adam beforehand, and I was saying about how we're looking at the 15 years of the Equality Act. So it's kind of the Equality Act's typical teenage years. The Equality Act has claimed, that this has been always what they've believed, and they've always believed they never were interested in something before. But what we're now discovering following this case is that sex under the Equality Act means biological sex. And in the understanding of the HRC and many other bodies, that sex under the Equality Act meant certificated sex, which I'll come on to in a second, but essentially that it referred to biological sex as well as sex acquired through an individual who obtains a full gender recognition certificate. And so this case looked at guidance produced by the Scottish ministers that related to legislation they produced that sought to promote women on some certain public boards. It sought to increase their representation on those boards, and in the guidance produced by the Scottish ministers, they stated that woman has the same meaning as in the Equality Act by 10, and that for those purposes, trans women with a full gender recognition certificate under the GRA, the woman within the meaning of the Equality Act. 4 women in Scotland challenged this guidance on the basis that it stated an error of law. That is not correct. That only those who are biologically female are those who fall within the definition of women under the Equality Act. Next slide, please. So what the court did in that regard was look at the meaning of the various terms that were relevant in these circumstances. First of all, looking at sex, woman, or looking at the 3 terms of sex, woman, and man. Essentially, because what the Supreme Court was deciding, or said it was deciding, was that it's looking for a coherency within the Act. What does the term mean throughout the Act? Can it mean different things and still be workable? And can it be can it still be workable? And given that it's needed to be used by people across the country, it needs to be accessible to them. It needs to be coherent in that sense. And so the core question was: did sex mean biological sex, i.e., sex recorded in your birth certificate at birth, or certificated sex, sex acquired by a person with a full gender recognition certificate? And what was accepted by all the parties, this only concerned trans people with a gender recognition certificate, which I think, as I checked beforehand, stands around 8,000 people, which is a very small percentage of an already small community of trans people. So it really referred to that group of people, whether they, as a result of their gender recognition certificate, could fall in the definition of woman and their sex, which under the Gender Recognition Act is said to be changed for all legal purposes, included for the purpose of the Equality Act. So those without a gender recognition certificate, in effect, were never able to be able to protection of sex unless there was associated discrimination or other forms of discrimination that are not related to your sex. However, what the effect and what the HRC complained of was that what this meant was that you couldn't, because of the restrictions about asking for gender recognition certificates, you couldn't always know if someone who was trans or who informed you they were trans, whether they had a gender recognition certificate or not. So it became a de facto position where those without a gender recognition certificate could access separate or single-sex services. What the HRC said that caused concern for those particular service providers. Next slide, please. As I mentioned at the start, what the Supreme Court decided was that sex, for the purpose of the Equality Act, is their biological sex. And therefore, as a consequence, a trans woman with a full gender recognition certificate is a man for the purposes of the Equality Act. And as a result, the guidance contained an error of law and was unlawful as a result. And so what the consequence of this means is that throughout all mentions of the Equality Act, sex means biological sex. And when looking at why this was, it looked at provisions in relation to in pregnancy and how it wouldn't quite work. In the Supreme Court's view, if it was to give women was to be given different meanings within the Equality Act. For example, trans men wouldn't have been protected under the pregnancy terms, despite if they were pregnant, given that they were biological females. The next slide, please. And so the Supreme Court gives various examples that I mentioned about in what circumstances this arises. So separate sex services, as I already discussed, and single sex services. But the difficulty in these circumstances is a lot of this is untested. It has been, I understand for the trans community, a very distressing time, but it has been an overhaul for what a lot of people understood the Equality Act to be. Of course, Forum Scotland have maintained that was the position always, but in practice, given that the HRC was issuing guidance that stated that this was the understanding of sex, and indeed had a position of inclusion for trans people as a starting point, that this meant that a lot of them were asking, and there's a lot of uncertainty at the moment. And so what is currently being undertaken by the EHRC is consultation as to their previous code, as a lot of it now incorrectly following the Supreme Court decision will say certain points regarding those specific provisions. What is less clear is how this works out in practice for service providers and how this is going to be enforced in practice. Although recently I believe there's been comments from the HRC regarding in some circumstances you can ask for birth certificates of individuals, and in practicality terms, a local cafe might not in reality be able to enforce that, and indeed whether the local cafe indeed does have to enforce it is a broader question. The HRC in their interim update notes that potentially there's a risk of indirect discrimination in not providing separate sex facilities, for example, in toilets. But similarly, you could raise the same argument for those characteristic of gender reassignment, i.e. trans people, then not being able to provide services that align with their gender, that you're indirectly discriminating against them in circumstances where you're not, as a service provider, relying on the single or the separate sex exemptions. And indeed, to return to the local cafe, it's not quite clear if every local cafe has conducted a proportionality assessment, considering the exclusion of trans people in those circumstances would be lawful. And the interim update is put in very strong terms regarding the separate sex provision, and that if you do decide to provide separate sex services, you must therefore exclude trans people who, on the basis, or rather, provide trans people service in relation to their biological sex. And I understand that this is potentially going to be challenged, and that the HRC, despite the update and the public statements they've made, have emphasised that this is that individual organisations will have to take advice on this. One can imagine circumstances in which there are valid direct discrimination claims on both sides, but what the future implications of this are relatively broad, given the far-reaching nature of the Equality Act. There's hundreds of provisions, and many refer to sex, some don't, and how that's going to be impacted on the kind of related legislation is not quite clear at present. There's related legislation in relation to work regulations and toilets in those circumstances, and by the Human Rights Act for each individual, if they're accessing a service, a public service, is very broad. And so taking a step back again to looking at how judicial review their role in this is that those who are implementing policies in public services and produce policies in relation to perhaps toilets, changing rooms, or other groups organised on the basis of perhaps sex or another protected characteristic, or on the basis of, for example, gender, although you wouldn't have the protections of sex, separate sex facilities, there still is, you have to justify your policy in those circumstances, and that would be susceptible to judicial review, and it's something that I'm sure many people will be considering in circumstances where they're representing trans individuals or they're representing gender critical individuals. And yeah, so that's my brief overview of the Forum in Scotland case. It's apologies, you're not hearing me very clearly. I'll speak a bit louder, hopefully that'll help. and perhaps it's my accent as well isn't helping. But one of the, speaking of my accent, one of the things that related to this is how this plays out in Northern Ireland as well. It's not clear, given that there is specific provisions in the Good Friday Agreement, that there's no distribution of rights up between, for those in Northern Ireland, between those north of the border and south of the border. And those south of the border have protections under EU law, which wouldn't necessarily take you to the point where the Supreme Court took us to in this decision. Now that's untested, and there's people who have written about it, and I'm not expressing a particular conclusion on that, but it's something that it doesn't necessarily follow, given that the Equality Act doesn't apply in Northern Ireland, and the Equality Act itself is, and the equality provisions in Northern Ireland are slightly complex, given that religion and legal belief are often seen as one and the same. Next slide, please. What I thought was helpful is to look at this case that preceded the For Women Scotland case, which is regarding Kingston's system for the provision of same-sex personal care for adult females who are being provided with services under the Care Act. This didn't rely on anything that was the previous erroneous understanding. It did highlight that the Supreme Court was looking at the question of sex and whether a female trans woman was a woman for the purpose of the Equality Act. And so I think it's a really helpful judgment in the sense that it's a very considered judgment from Justice Helen Williams about how the importance of an individual's belief that they should be provided with same-sex personal care and the systems that are in place, and how an individual organisation can look to discharge its duty and indeed to ensure that there's no discrimination. And so the claimant argued on two bases of whether there was a breach of their individual's rights. First, that there was a combined duty to operate a system that ensured the provision of same-sex personal and intimate care for female service users by default, subject to some limited exceptions, for example, where there was an urgent need for care or other, and there was no available female personal care providers. And similarly, as a result of this, the combined duty required the defendant to record the sex of its service users. Next slide, please. What the claimant argued was that the combined duty existed as a result of the Care Act, guidance, Article 3, Article 8, and the Equality Act, looking at direct discrimination and the public sector equality duty. Mr. Justice Helen Williams looked at each of those provisions and effectively found that there was no such combined duty, although Article 8 in and of itself did require that there be adequate systems and that a risk of any sort of harm be put to a reasonable minimum. That duty in this case was that would have in any event been discharged, given that the local authority didn't have a system by which in practice they are providing same-sex care for those who wish to have it, and indeed that came from the Care Act itself, which considered factors of dignity for the individual and that their interests be considered, etc. So it did look at did look at all these points that are and said, well, in effect, this duty doesn't exist on the basis that you put forward, and even if it does, perhaps under Article 8, there is already a system in place. And that's where, in that case, the Equality Act challenge fell as well, on the basis that the public sector equality duty challenge was contingent on there being combined duty, and so it fell away, where there was no combined duty. But similarly, indirect discrimination didn't occur because, in practice, what was happening was what the claim was arguing was a practice that didn't exist. And so, in those circumstances, it also, as a consequence, meant there was no duty to record the sex of the service user. And indeed, ultimately, what was found was that there was evidence that it did occur in practice. And this is Helen Williams noted, the importance of individual beliefs, and that there was a real importance that their dignity was necessary, etc. But ultimately found against the claimants in that way. And I'll provide the citations in the follow-up slides, but she goes through quite carefully each of those provisions and looks at how this would work in practice and how it would be work in practice. And what I think it's useful for in terms of considering where we're going, the Equality Act, it's setting out, well, one thing to consider in these claims that might arise as a result of the form in Scotland decision is that there has to be consideration of, well, what is the less favourable treatment in those circumstances? What is the practice that you're arguing, and is it in reality in existence, or what evidence is there to provide it? And this is a thing that when considering challenges under judicial review, claimant representatives will want to consider what is the evidence that we have. Is it solely based on this individual case, and it's an individual breach, or can we argue a more systemic breach? And that will often not necessarily become clear until later on when we're provided with the evidence to the defendant, and that appears to be what happened in this case. Where they produced further evidence and witness statements detailing how in practice this worked, which the claimant obviously could not have known beyond their individual care. Next slide, please. And so then turning to the immigration context, the recent case challenging the Home Office's process for allocating asylum support claimants accommodation, which resulted in them being placed in Wethersfield, the former RAF barracks, was challenged in this case. The claimants argued, I'll deal with those points in relation to the Equality Act. They argued that there was an unlawful allocation of accommodation policy. There was two versions that were produced because claimants challenged the case at different points and a different version of the guidance was produced. And insofar as relevant, they argued that there was a breach of the public sector equality duty, and there was a systemic failure to make reasonable adjustments. And in the individual case, there was in individual cases that were breached of the Equality Act, mainly the duty to make reasonable adjustments. Next slide, please. And so, by way of background before getting into this point, is that there were, prior to the versions 11 and 12 of the allocation of accommodation policy, version 10 provided that where an individual is vulnerable or has a disability, they must have mobility or disability in those senses, must not be provided with accommodation in what was known as large scale sites or large vessel sites, such as Wethersfield or Billy Stockholm, which will list the boats that is and what was looked at in this case was the fact that what happened was that version 10 was provided, and then version 11 and 12 both changed must to may for those circumstances, and so it put more weight on the discretion of the defendant. The difficulty for the defendant in this case was that the equality impact assessment produced at that time predated the 11th and 12th version of the allocation of accommodation policy. And so there was no consideration of what the impact would be for those who were who would be the definition of disability, particularly those who have mobility issues. The equality impact assessment from version 10 did find that did state that those who have mobility issues and severe disabilities wouldn't be provided with accommodation at large scale sites, given that it would not be suitable for them, including Wethersfield. And so in those circumstances, we quite forceful judgment in what is overall, unfortunately, a successful claim. Quite forcibly, Mr. Justice Mould held there was a breach of the public sector equality duty because there is no way in which the defendant could know that what the impact was. As Absar pointed out, what we're looking at in this kind of context is the ongoing nature of the duty and the duty to monitor what the outcome of these the certain provisions are, particularly here where there's a change in policy and where previously the position was that they had said they would not be provided with large-scale accommodation in this sense. And so the defendant couldn't possibly know and didn't produce any further equality impact assessment or seek to kind of, in hindsight or retrospect, cover their tracks in that sense. They maintained their position that there was no breach of the public sector equality duty. On the contrary, there was consideration that there was no breach of the systemic duty to make reasonable adjustments. This is where the judgment perhaps becomes hard to follow on the basis that, well, if you aren't considering and monitoring what the provision of this accommodation is, how can you be proactively making adjustments on a systemic level? And the judicial board held that because of the nature of the allocation of accommodation policy, which it might be unlawful, was that there was many factors that would be taken into account. So information provided in their screening interview, the information provided in their asylum support application form, that this was enough to satisfy the systemic duty to make reasonable adjustments. However, there was finding in an individual case that there was a breach of the duty to make reasonable adjustments, given that from the very outset, what this system was that was held to be lawful was not followed because they didn't make reasonable adjustments after the individual TG claimant made disclosures regarding his torture and severe mental health difficulties, and that was compounded by evidence that was subsequently provided that noted that that claimant had deteriorated, mental health had deteriorated. I'm going to not go on to the last case just on the basis that we have limited time, but just to kind of pause again and note that in these circumstances, what it's how the Equality Act in some ways evolved, but in many ways stayed the same, is that there's this heavier emphasis on monitoring in these circumstances, particularly where there is a particular vulnerable cohort for those with disabilities, for example, in the context of asylum accommodation, in the accommodation estate more generally for those who don't have regular immigration status. And so as that goes forward, that will continue to be an issue that I think will crop up and be a really useful tool for claim practitioners who are seeking to judicial reviews, because government deals with a lot of people, particularly in the immigration sphere, and it doesn't regularly keep up-to-date information on a lot of those people. I think, for example, the cases I've been involved in the context of no recourse to public funds, and the data that they're relying on, I believe, is from perhaps as far back as 7 8 years ago, and that they have updated their quality impact assessment, but not considering recent data. When you consider that that data is considered as from the time of pre-dated COVID, disparities in equality impacts will be far greater, and so there's plenty of avenues where there will be a right challenge on a monitoring basis of the PSED. Thanks for bringing anything there. I think we'll see if we have any questions. And here, and here, I'm sorry if you struggled still.
Yeah, sorry about the sound problems, everyone. So we've got a few minutes left. If anyone has any questions, please do feel free to put them in the Q&A. While we're giving you a chance, everyone, I'm sure to flood us with fascinating questions. It's 5:55 when it's sunny outside. Just to say, on the duty to make reasonable adjustments in this context as a public lawyer, don't forget that the starting point for your test is to look at the systemic position. So you have to ask whether there was, whether disabled persons as a whole, so the category you're looking at, for example, blind transport users or wheelchair users in prison, the category is itself put at a substantial disadvantage, and whether there was a failure on the category level to make reasonable adjustments. And that's stage one, and it's only if that if there's a failure at that stage that you then go on to look at the specific circumstances of your case. And it's quite important to bear that in mind, because a few cases have failed because they've applied the wrong approach. Anyway, that's just an aside. We don't have any questions coming into the chat, so I think it's just to leave me to say thank you very much for joining us, and yeah, I hope you have a wonderful sunny afternoon.